Artificial intelligence, machine learning, and big data. A look at the Bulgarian law in this field as of 2021. First, let's have a look at the trends in this field in Bulgaria. When talking about the legal aspects of artificial intelligence and big data in Bulgaria, a few words must be said concerning the specific structure of the legislation and the market it creates. These specifics remain largely unchanged due to the COVID-19 crisis. On the one hand, Bulgarian law, while compliant with the standards of the World Intellectual Property Organization and the international treaties on the protection of IP rights, has a long way to go in terms of regulating the creation and use of software, databases, etc. Currently, the regulation remains focused on literary works, and software is being treated as such, while databases are getting similar treatment to periodical literature issues, anthology works, and other compilations of works. This raises particular problems with licensing, use, updates, and maintenance of software systems, AI included, as well as with the use and protection of databases, which will be discussed below. National legislation shows almost no orientation towards innovation, but is only one of the sources of law in this field. As a member state of the EU, Bulgaria must observe the primary EU law, treaties between the member states, and guarantee that the national legislation is harmonized with the secondary EU law. The secondary EU law consists of regulations which have direct effect in all member states and have primacy over national law, and directives which set guidelines for the national legislation, which should be implemented with adequate national measures. These directives are criteria for the interpretation of national law of the member states, and when their implementation is delayed, they can have direct effect as well. Additionally, the Court of Justice in Luxembourg has the authority to interpret the primary and secondary law, and in certain cases, it can formulate concrete rules from rather more abstract principles of EU law. The Court of Justice of the European Union has a major role and can introduce rules, including concerning innovation, much faster than the standard EU legislative procedure. Within this legislative framework, the Bulgarian IT industry is flourishing, mainly because of the low setup expenses for businesses and the specific economic situation, which allows IT specialists to maintain a high standard with relatively lower wages. This creates a highly competitive environment focused on innovation, but practice shows that all of the attention is reserved for the product under development. Matters of internal relations between partners, ownership over software, are often overlooked until they become highly problematic. More complex questions such as ownership, predictability, interoperability, liability are mostly ignored in both the national legislation and by businesses. In terms of trends, which will definitely affect the development of the market, in February 2020, the European Commission published a white paper on AI and a European data strategy. While these documents have mainly political aims, they formulate a general requirement that AI will not be considered a black box, which will take decisions on the basis of input data without control. AI must be trustworthy and will not be allowed to take opaque or biased decisions. The data strategy presupposes that big data will mean more and more for businesses in the future, and that it is expected that larger and larger amounts of data will be gathered from enterprises. The data strategy emphasizes the free access to data, but also states that companies gathering data with regard to other services might create an unbalanced data market. Focus falls on guaranteeing the protection of competition, educating everyone on the market about their data-related rights, and encouraging small and medium-sized enterprises to create, use, and operate on the data market. The EU legislation is focused on consumers' rights and the protection of competition as well as the free flow of data between member states, including from and to the public sector. Examples in that regard are the free flow of data regulation and the open data directive. And another legislative act has been discussed for quite a while now, the e-privacy regulation, which extends the standards introduced by the General Data Protection Regulation to every type of electronic data, as well as introduces rules on updates of software and requirements for the use of the terminal devices by software manufacturers. Going further on these topics, while observing the same principles, the European Parliament accepted several resolutions in October 2020, which will be the basis of future legislative acts. These resolutions can be considered an extension of the white paper on AI, but introduce some very important legislative concepts. On the ownership over intellectual property created with the assistance of or directly by AI, civil liability for the actions of an AI, depending on the type of activity, use of algorithms, etc. Summary of the resolution is very difficult due to the number and complexity of problems discussed, but they give a strong indication that EU law in this field is about to change and that for now AI will not be granted legal personality as means of addressing the problems of its regulation. A part of these trends relate to COVID-19. The pandemic showed that large groups of people can be organized to work from home. This required a different level of organization, both for everyday work and for businesses to adapt to the needs of customers who stay at home almost exclusively. As a result, the deficiency of national legislation in the field of technology were thrown in sharp relief. The necessary organization implied use of technology which was made nigh impossible by regulations more suitable for paper documents and processing of small amounts of data. As a result, the market shows the signs of an upcoming disaster. An old national legislation, together with businesses left without any form of supervision whatsoever, which are about to be hit by the next wave of EU legislative measures intended to have a wider and deeper impact than GDPR. Such a legislative measure is already in the works. There is a proposal for AI regulation, which is currently being discussed, and it is pending to see when it will be ready.